Hi, my name is Akiva Goldman. I'm the director and founder of Goldman and Associates. Our firm has a primary focus on family law issues here in Michigan. And today we're going to continue our video series designed to educate and inform the public, so please subscribe to our channel. Risk-taking during parenting time is always an issue. A lot of times parenting time, involves one parent maybe taking the kid to do something that maybe the other parent wouldn't necessarily do, and is at an unreasonable risk. I mean, even in happily married couples, you may find that dad is willing to let the children do something, mom not. Or, it could be even, letting the kids go on the Ferris wheel by themselves. Mom may not be comfortable with that. Maybe dad is. So even in the context of good relationships, sometimes we have different views of what is risky and what is not. So certainly in the context of separated situations where mom will say, well, I don't have to listen to you anymore, and dad will say, your rules don't mean anything, man, I'm doing it my way. Where do we fit in on this? So if the court believes that there's an inherent risk that one parent is subjecting the children to during their parenting time, the court will take action on this. The court might limit the activity or limit the parenting time, maybe even suspend it altogether if it can't get compliance. But you have to remember that what you say is risky might not necessarily be risky in the eye of the court. Not only that, but even if the court feels it's risky on a personal level, that doesn't mean the court is going to grant your motion to limit the activity. The court may feel that skiing is risky. You break a leg. And maybe the judge wouldn't go skiing. But the court at the same time can recognize that even though the judge personally thinks it's risky, this is something that people do. This is something that people enjoy. And dad wants to take the kids skiing and mom doesn't want to. Well, you know what? So you tell the dad, be very careful, make sure they're wearing ski helmets, make sure they get appropriate lesson beforehand so they know what they're doing. And the court is likely going to allow that. I mean, there are certain hobbies. Now, will the court allow something extreme? Maybe not. Will the court necessarily, if there's an issue on the kid's 16th birthday, is the court going to let you give the kid a motorcycle or something like that? The court may view that as extremely dangerous. Personally, I was just watching a Netflix show, and the whole thing started out because on the 16th birthday, a father gave a kid a motorcycle-type bike, and the kid was flying through the street and had a head-on collision, or actually a T-bone collision, got killed. I mean, and the whole series flowed from everything that went on with that. But, the court may view something like that as risky business and something that the court might put a stop to. But most activities that go on in life that a lot of people might think are ultra risky may or may not be viewed in that way. So you've got to be very careful about that. If you want to file objections to something or file a motion to have the court to limit something, talk to your attorney about it and say, look, I believe this is risky. Here's why. Do you think the court will see it my way? And if your attorney says, you know what, I hear what you're saying, let's put in some safeguards, but I don't know that the court is necessarily going to grant that motion, you might want to consider not doing it. If they can't say it's at least better than a 50-50 shot, it's likely that it's probably not an investment worth making in terms of hiring your lawyer to file such motion. So give that some thought. If you have any questions, though, reach out and we'll be glad to help you out.